I knew something was wrong the second I saw Brenda Carmichael standing on my front porch with that clipboard pressed against her chest like a shield. Her lips pursed so tight they disappeared into a thin line of disapproval. It was a Tuesday morning in late April, and I'd just finished hanging my laundry on the clothesline I'd installed the previous weekend in my backyard here in Fort Collins, Colorado. The sun was bright, the air was crisp, and I'd been feeling pretty good about reducing my carbon footprint until I opened the door to find the HOA president looking like I'd personally insulted her entire bloodline. "Oliver Bradford," she said, not even bothering with a greeting. "We need to talk about your little addition to your backyard." I leaned against the doorframe, coffee mug in hand. "Good morning to you too, Brenda. What addition are you talking about? Don't play dumb with me." The clothesline. Section 12. Paragraph 4 of our community guidelines explicitly prohibits any outdoor drying apparatus that's visible from neighboring properties or the street. "It's in my backyard," I pointed out, "and I checked the CC and Articus before I installed it. There's nothing in there about clotheslines specifically." Brenda's face flushed red, making her look like an overripe tomato. "It falls under unsightly outdoor fixtures. We've had 3 complaints already." 3 complaints? I put it up 2 days ago. Who's even seeing it? "That's not the point, Oliver. The point is that Meadowbrook Estates maintains certain standards, and clotheslines are not part of those standards. They're tacky, they lower property values, and they attract attention from undesirable elements." I nearly choked on my coffee. Undesirable elements. "Brenda, it's laundry. Clean laundry, I might add. What undesirable elements are attracted to clean sheets? The rule stands. You have 72 hours to remove it or you'll be fined $500 for your first violation." She thrust a formal notice at me, already filled out in her precise, angry handwriting. I took the paper, reading through the bureaucratic nonsense. "This is ridiculous. Do you know how much energy dryers use? I'm trying to be environmentally conscious here." "Then be environmentally conscious with an indoor drying rack like a civilized person." Brenda turned on her heel, her sensible flats clicking against my concrete walkway. 72 hours, Oliver. I'll be checking." I watched her march back to her white sedan, already on her phone, probably calling her fellow board members to crow about putting another rebel homeowner in their place. I'd lived in Meadowbrook Estates for 2 years, ever since my divorce, and Brenda had been a constant thorn in my side. My grass was too long, then it was too short. My garbage cans were visible for 20 minutes past the allowed pickup time. My doormat was the wrong shade of brown. The woman had nothing better to do than police a neighborhood of 43 homes like it was her personal fiefdom. I went back inside and pulled up the community guidelines on my laptop. I'd read them before buying the house, but I'd obviously missed something. Except when I searched through every page, every subsection, every addendum, there was nothing specifically about clotheslines. The section on unsightly outdoor fixtures mentioned satellite dishes, certain types of fencing, and improperly stored vehicles. Clotheslines weren't mentioned at all. That afternoon, I called my neighbor, Marcus, who'd lived in the neighborhood for 8 years. He laughed when I told him about Brenda's visit. "Oh man, welcome to the club. She tried to fine me last year because my Christmas lights weren't the approved white color. I had multicolored ones, you know, like a normal person who enjoys Christmas." She actually measured the distance from my roofline to make sure they were exactly where the guidelines specified. "So, what did you do?" "Took them down. It wasn't worth the fight. Brenda and her board, they'll make your life miserable if you don't comply. Trust me, I've seen it happen." The Johnsons down on Maple Court fought a fence violation for 6 months. The legal fees alone were astronomical, and they ended up having to comply anyway. I hung up feeling frustrated. $500 for hanging laundry seemed insane, but if the HOA could stretch their interpretation of unsightly fixtures to include a simple clothesline, maybe I was fighting a losing battle. I spent the evening researching HOA disputes, reading horror stories about people losing their homes over unpaid fines, about boards that operated like small-time dictatorships. It was depressing, but something kept nagging at me. I remembered reading an article a few years back about some states passing right-to-dry laws, legislation that prevented HOAs from banning clotheslines. I couldn't remember if Colorado was one of them, but it seemed worth looking into. The next morning, I drove to the local library and asked the librarian, an older woman named Patricia, if she could help me research Colorado state laws. She directed me to a computer terminal with access to the state legislature's website. It took me almost 2 hours of searching through dry legal text, but then I found it. Colorado House Bill 1309, passed in 2008. The law specifically stated that homeowners associations could not prohibit the use of clotheslines or other energy-efficient drying devices. The statute was crystal clear. Any covenant, restriction, or condition that violated this was void and unenforceable. I printed out 3 copies of the relevant statute, my hands actually shaking with excitement. Brenda and her board had no legal leg to stand on. Their rule, their interpretation, all of it was completely meaningless in the face of state law. I drove straight to the HOA office, a small converted house on the edge of the neighborhood that served as Brenda's command center. Her car was in the driveway. I knocked firmly on the door. Brenda answered, looking annoyed. "Oliver, have you come to tell me you've removed that eyesore?" "Actually, no, I came to give you this." I handed her one of the printed copies. Colorado House Bill 1309, passed in 2008. It specifically prohibits HOAs from banning clotheslines. Your rule is void. Unenforceable, illegal actually. I watched the color drain from her face as she scanned the paper. Her jaw worked, but no sound came out for a good 10 seconds. I'll need to verify this with our attorney," she finally stammered. "You do that. But in the meantime, I'll be keeping my clothesline exactly where it is, and you can tear up that violation notice." I was probably enjoying her discomfort more than I should have, but after 2 years of her petty tyranny, it felt good to finally push back. "The board will still need to review this," Brenda insisted, but her voice had lost its usual authoritative edge. "The board can review the sky's blueness while they're at it. State law trumps HOA rules. That's not debatable." I turned to leave, then paused. "Oh, and Brenda, you might want to check the rest of your rules. If this one's illegal, who knows what else you've been enforcing that you have no right to enforce." I left her standing in the doorway, the paper clutched in her hand, looking like someone had just told her Santa wasn't real. The next few days were blissfully quiet. My clothesline remained in my backyard, my laundry drying naturally in the Colorado sun. I'd almost forgotten about the whole incident when I got a knock on my door on Saturday morning. This time it was Gerald Thompson, the HOA vice president and Brenda's loyal lapdog. He was a thin man in his 60s with a comb over that fooled absolutely no one. "Oliver, we need to discuss your defiance of board authority," he began. "No defiance, just following state law. Something the board should try doing." Gerald shifted uncomfortably. "The board has consulted with our attorney. While the statute you referenced does exist, there are certain interpretations and exemptions that may apply to our specific situation." "Really? What interpretations would those be?" "Well, for instance, if the clothesline poses a safety hazard, or if it's not properly maintained, or if it's used in a manner that creates a nuisance to neighbors. My clothesline is sturdy, well-maintained, and I use it to dry clean laundry. Unless you're arguing that clean sheets are a nuisance, you don't have a case. There's also the matter of aesthetic considerations. The law may protect your right to have a clothesline, but it doesn't mean you can have it anywhere or make it as large as you want. I crossed my arms. It's a standard clothesline, T-shaped, 7 feet tall in my backyard. It's not visible from the street. I'm not drying car covers or circus tents on it. I'm drying normal household laundry. Gerald pulled out his phone and showed me a photo. It was my backyard, clearly taken from someone else's second-story window. Mrs. Pembroke, your neighbor, can see it from her bedroom window. She finds it distressing. Mrs. Pembroke finds everything distressing. She complained when I planted tomatoes because she said the red color was too aggressive. Nevertheless, the board is considering a fine for violating the aesthetic harmony of the neighborhood. I pulled out my phone and called up the statute I'd saved. Let me read you something, Gerald. No homeowners association shall prohibit the use of clotheslines or other energy-efficient drying devices, not may sometimes allow or can regulate extensively. It says shall not prohibit. That's about as clear as legal language gets. Our attorney says there's room for reasonable restrictions. Then your attorney is wrong, or you're not listening to what they're actually saying. Reasonable restrictions might mean I can't put it in the front yard or make it 20 feet tall, but a standard clothesline in my backyard. That's protected, period. Gerald's face hardened. The board will be voting on this matter at our meeting next week. If we determine that your clothesline violates our standards, regardless of this statute, we will enforce our rules. You can attend the meeting if you wish to make your case. Oh, I'll be there, I assured him. After Gerald left, I realized this was going to be a bigger fight than I'd anticipated. Brenda and her board weren't going to back down just because the law was clearly on my side. They'd spent years building their little kingdom, and they weren't about to let some upstart homeowner with a clothesline tear down their authority. I spent the next week preparing. I researched every case I could find about Colorado's right to dry law. I found articles about similar disputes in other states, including cases where HOAs had been forced to pay legal fees after losing in court. I printed out everything I could find, organized it in a folder, and practiced what I was going to say. On the day of the meeting, I arrived 15 minutes early. The HOA meetings were held in the clubhouse, a small building near the neighborhood pool. About 20 residents were already there, which was unusual. Normally, these meetings attracted maybe 5 or 6 people, mostly retirees with nothing better to do. Word must have spread about the clothesline controversy. Brenda sat at the head table with Gerald and the other 3 board members. Sharon Mitchell, a woman in her 50s who always wore too much perfume. David Hutchins, a former accountant who treated every HOA penny like it was his own. And Margaret Yates, who rarely spoke but always voted however Brenda wanted her to vote. Brenda called the meeting to order at 7 o'clock sharp. She went through the usual business: approval of last month's minutes, financial reports, updates on landscaping contracts. I sat patiently, my folder in my lap, waiting for my turn. Finally, she reached the agenda item labeled Violation Discussion, Bradford Property. As many of you are aware, Brenda began, her voice dripping with disdain, Mr. Oliver Bradford has installed a clothesline in his backyard in direct violation of our community standards. Despite being notified of this violation, he has refused to comply and has instead chosen to challenge the authority of this board. A few murmurs went through the crowd. I saw Mrs. Pembroke nodding vigorously. Mr. Bradford, Brenda continued. You may have 5 minutes to address the board. I stood up, folder in hand. Thank you, Brenda. I'll try to be brief. In 2008, the Colorado legislature passed House Bill 1309, which I'm sure you're all now familiar with. This law specifically protects the right of homeowners to use clotheslines and other energy-efficient drying methods. The law states, and I quote, "No homeowners association shall prohibit the use of clotheslines or other energy-efficient drying devices." I held up the printed statute. This isn't ambiguous. It's not open to interpretation. State law explicitly overrides any HOA rule that bans clotheslines. My clothesline is a standard size, properly installed, and used exclusively for drying laundry. It's in my backyard, not my front yard. I'm not violating any reasonable aesthetic standards. I'm simply exercising my legal right as a Colorado homeowner. The board has already reviewed this statute, Brenda interrupted. We believe there are reasonable restrictions we can impose that don't constitute an outright ban. Except you didn't try to impose restrictions. You ordered me to remove it completely. That's a ban, which is explicitly illegal. Sharon leaned forward. But you didn't seek approval before installing it. Our rules require pre-approval for any outdoor structures or installations. The state law supersedes that requirement. You can't require approval for something you're legally prohibited from banning. If I asked for approval and you denied it, that would be an illegal prohibition. The law protects my right to install and use a clothesline without HOA interference. David Hutchins spoke up. What if everyone in the neighborhood decided to put up clotheslines? We'd have laundry flapping everywhere, looking like a trailer park. Several people gasped at that comment. I saw Marcus, who'd come to the meeting to support me, shake his head in disgust. First of all, that's a pretty offensive characterization. Second, so what if people want to use clotheslines? It's their legal right. This isn't about what looks nice to you or maintains some artificial standard of suburban perfection. This is about state law protecting homeowners' rights to make environmentally conscious choices. Environmental consciousness is fine, Brenda said sharply, but not at the expense of property values. Homes in Meadowbrook Estates command premium prices because we maintain standards. If we allow clotheslines, what's next? Vegetable gardens in front yards, chickens. Actually, Colorado also has laws protecting the right to keep bees and grow vegetables, but that's a different discussion. The point is, you can't enforce rules that violate state law. If you try, you're opening this HOA up to legal liability. Brenda's face flushed red again. Are you threatening to sue this board? I'm pointing out facts. If you fine me or take any punitive action against me for having a legal clothesline, yes, I'll challenge it. And I'll win because the law is completely clear. You'll waste HOA money on legal fees defending an indefensible position. The room erupted in conversation. Some people were nodding in agreement with me, others were shaking their heads. Mrs. Pembroke stood up, her voice shrill. This is exactly the kind of attitude that's ruining this neighborhood. We moved here for peace and quiet and standards, not to look at people's dirty laundry. It's clean laundry, Mrs. Pembroke, I said tiredly. That's literally the point of hanging it out to dry. Order, Brenda banged her gavel. We will now take a vote on whether to uphold the violation notice against Mr. Bradford and impose the $500 fine. All in favor? Brenda, Gerald, and Margaret raised their hands immediately. Sharon hesitated, then raised hers about halfway. David kept his hand down. 4 in favor. Motion passes. Mr. Bradford, you have 72 hours to remove the clothesline or the fine will be assessed to your account. I took a deep breath, keeping my temper in check. Then I'll see you in court. This vote doesn't change the fact that your rule is illegal and unenforceable. You can pass whatever motions you want, but you can't override state law. I walked out of the meeting to the sound of heated arguments breaking out behind me. Marcus caught up with me in the parking lot. "That was brutal," he said. "But you're right. They can't do this." I know I'm right. The question is, how much time and money am I going to have to spend proving it? The next morning, I found a formal violation notice in my mailbox, along with an invoice for $500, due within 30 days. I took photos of everything and called a real estate attorney whose name I'd found online, Mitchell Green. His office was in downtown Fort Collins, a modest suite in an older building. Mitchell was in his 40s, balding, with the tired eyes of someone who'd seen too many pointless disputes. When I explained my situation, he actually laughed. "Let me guess. Brenda Carmichael is your HOA president? You know her." "I've handled 3 cases against Meadowbrook Estates in the past 5 years. She's a piece of work. The good news is you're absolutely right about the law. The bad news is she's stubborn enough to drag this out as long as possible." "So what do I do?" Mitchell leaned back in his chair. "First, you don't pay the fine. That could be seen as accepting the validity of their rule. Second, you keep the clothesline up. Third, when they escalate, which they will, you file a lawsuit for declaratory judgment. We ask the court to rule that their prohibition is void under state law. It's pretty cut and dried." "How much will that cost me?" "My retainer is $2,000. If we go to court, maybe another $3,000 to $5,000, depending on how much they fight. But here's the thing, if we win, which we will, we can ask the court to order the HOA to pay your attorney fees. They're enforcing an illegal rule, and there's case law supporting fee awards in these situations." I thought about it. $7,000 in potential legal fees was a lot of money, but the principle of the thing was eating at me. Brenda and her board had been bullying people for years, and nobody had ever stood up to them effectively. "Let's do it," I said. Mitchell smiled. "I was hoping you'd say that. I'll draft a letter to the board first, one more chance for them to back down before we file suit. Sometimes that's enough to make them see reason." 3 days later, Mitchell sent his letter to the HOA board. It was a beautiful piece of legal writing, polite but firm, laying out exactly why their prohibition was illegal and warning them of the consequences if they continued. He cited the statute, he cited case law from other right to dry disputes, and he made it crystal clear that they would lose in court. Brenda's response came 2 days after that. It was a single page, printed on HOA letterhead. "The Meadowbrook Estates Homeowners Association stands by its rules and regulations. Mr. Bradford's clothesline remains a violation of our community standards. The fine stands. If Mr. Bradford wishes to challenge this, he is welcome to do so through appropriate legal channels." Mitchell shook his head when I showed him the letter. "She really is determined to do this the hard way. All right, let's file the lawsuit." The complaint was filed in Larimer County District Court 3 weeks later. We asked for declaratory judgment that the HOA's prohibition was void and unenforceable, an injunction preventing them from enforcing it, and attorney fees. The filing fee alone was $400, but I was committed now. The HOA had 20 days to respond. During that time, I kept using my clothesline. Every time I hung out my laundry, I imagined Brenda stewing in her house, furious that I was openly defying her. It probably wasn't the most mature attitude, but it felt good. Their answer to the complaint was filed exactly on day 20. The HOA had hired their own attorney, a firm out of Denver that specialized in HOA disputes. Their answer was full of legal jargon, but the basic argument was that they had the right to impose reasonable restrictions on clotheslines, and that their prohibition was such a restriction. They also argued that I'd violated proper procedures by not seeking pre-approval. Mitchell laughed when he read it. They're grasping at straws. Neither of those arguments holds water. The statute doesn't provide for reasonable restrictions, and the pre-approval requirement can't apply to something they're prohibited from banning. So we'll win. We should. But judges can be unpredictable, and Brenda's attorneys are expensive. They'll drag this out as long as they can, hoping you'll give up. He was right about the dragging out part. The next 6 months were a blur of legal motions. The HOA filed a motion to dismiss, arguing we hadn't exhausted internal remedies. We opposed it, pointing out that the board's vote constituted exhaustion of remedies. The judge denied their motion. Then they filed for summary judgment, essentially asking the judge to rule in their favor without a trial. We filed our own cross motion for summary judgment. This was where Mitchell really earned his fee. His brief was 30 pages of airtight legal reasoning, complete with citations to every relevant case and statute. He demolished their arguments point by point. The hearing on the summary judgment motions was scheduled for October, 6 months after I'd first hung up my clothesline. I took the day off work to attend. The courtroom was smaller than I'd expected, wood-paneled and slightly stuffy. Brenda was there with the entire board, all of them looking grim. Their attorney, a sharp-dressed woman in her 30s named Patricia Rowlands, looked confident. Mitchell looked relaxed. Judge Amanda Kerrigan entered and we all stood. She was in her 50s, with short gray hair and reading glasses perched on her nose. She'd clearly read all the briefs because she got right to it. "This seems fairly straightforward to me," she began. "Colorado has a clear statute protecting clotheslines. The HOA has a rule prohibiting them. Counsel for the HOA, can you explain to me how your rule doesn't violate the statute?" Patricia Rowlands stood. "Your Honor, we're not prohibiting clotheslines entirely. We're simply requiring that they meet certain aesthetic and procedural standards. The plaintiff didn't seek approval before installation, and the placement of his clothesline is visible to neighbors, which violates our aesthetic standards. But the statute says you shall not prohibit clotheslines. That language is pretty absolute. Where in the statute does it provide for aesthetic requirements or pre-approval processes? Your Honor, we believe the statute should be read in harmony with property rights and the legitimate interests of homeowners associations in maintaining property values." Judge Kerrigan looked skeptical. The legislature could have written the statute to allow reasonable restrictions. They didn't. They wrote "shall not prohibit." That's about as clear as statutory language gets. "Mr. Green," Mitchell stood. "Your Honor, this is exactly why the statute was written the way it was." Legislators knew that HOAs would try to regulate clotheslines out of existence through aesthetic rules and procedural requirements. The statute uses absolute language specifically to prevent that. My client has a standard clothesline in his backyard, used for its intended purpose. The HOA's attempt to prohibit it is a clear violation of state law. What about the pre-approval requirement? Your Honor, you can't require approval for something you have no legal authority to ban. If the HOA could deny approval, that would be an illegal prohibition. If they have to approve it, then the pre-approval requirement serves no purpose. Either way, it can't be used to circumvent the statute. Judge Kerrigan nodded slowly. "I'm inclined to agree. I'll take this under advisement, but I'll tell you now, counsel for the HOA, your arguments are not persuasive. This statute is clear, and I don't see any legal basis for your position. I'll issue a written ruling within 30 days. We left the courtroom. Mitchell was grinning. That went about as well as it could have. She's going to rule in our favor. How can you be sure? 20 years of reading judges. She'd already decided before we even argued. She was giving the HOA a chance to come up with something persuasive, and they couldn't. He was right. 3 weeks later, the ruling came down. 8 pages of clear, decisive legal analysis. Judge Kerrigan ruled that the HOA's prohibition was void and unenforceable, that state law clearly protected my right to have a clothesline, and that the fine against me was invalid. She also ordered the HOA to pay my attorney fees, which by that point had reached almost $6,000. I called Mitchell as soon as I got the ruling. We won. We did. And they're going to pay for their stubbornness. I'll submit my fee statement to the court next week. I thought that would be the end of it, but I'd underestimated Brenda's determination. The HOA filed an appeal. Can they do that? I asked Mitchell. They can, but they're throwing good money after bad. The law is too clear for an appeals court to overturn. They'd need to find an error in the judge's legal reasoning, and there isn't one. She applied the statute correctly. So what happens now? We wait. Appeals take 6 to 9 months typically. In the meantime, the ruling stands. You keep your clothesline and they can't fine you. The appeal process was even more tedious than the original case. Written briefs, responses to briefs, replies to responses. Mitchell handled all of it, keeping me updated. The appeal was finally argued before a 3-judge panel of the Colorado Court of Appeals in June, almost a full year after I'd first installed my clothesline. I didn't attend the appellate argument. Mitchell went alone, since it was mostly procedural. He called me afterward. Quick hearing. The judges asked the HOA's attorney some tough questions. One of them actually said the statute seemed breathtakingly clear. I think we're in good shape. The appellate opinion came down in August. It was even more decisive than Judge Kerrigan's ruling. The 3-judge panel unanimously affirmed, writing a scathing opinion about HOAs trying to circumvent clear statutory protections. They upheld the attorney fee award and added the appellate attorney fees as well. The total bill to the HOA was now over $12,000. I ran into Brenda at the grocery store a week after the opinion came down. She was in the produce section, examining tomatoes with the same critical eye she usually reserved for HOA violations. When she saw me, her face went through several interesting color changes. "I hope you're satisfied," she said coldly. "You've cost this association thousands of dollars in legal fees." "I didn't cost the association anything, Brenda. You did. I told you from the beginning that the law was on my side. You could have backed down at any point. Instead, you wasted everyone's money trying to enforce an illegal rule. This isn't over. There are other ways to maintain standards in this neighborhood. As long as those ways don't violate state law, I've got no problem with that, but you might want to review your other rules. If you're enforcing other illegal provisions, you're opening the association up to more lawsuits." She turned away without responding, abandoning her tomatoes and stalking off toward the checkout. I actually felt a little sorry for her. She'd built her identity around being the HOA president, around maintaining control, and she just learned the limits of that control in a very expensive and public way. The HOA had to pay the judgment, which meant a special assessment on all the homeowners to cover the legal fees. This did not make Brenda popular. I started getting friendly nods from neighbors who'd previously avoided me. Marcus told me there was talk of a recall election for the board. "People are pissed about the assessment," he said. $500 per household, all because Brenda couldn't let go of her grudge. There's a petition going around to force a recall vote. The recall election happened in October, almost 18 months after I'd first installed my clothesline. All 5 board members were on the ballot. Brenda, Gerald, and Margaret were voted out. Sharon and David kept their seats by narrow margins, probably because they'd shown some reluctance during the original vote. 3 new members were elected, including Marcus and a retired lawyer named Frank O'Connor, who'd been openly critical of the board's handling of my case. The new board's first act was to formally rescind the clothesline prohibition and issue a public apology to me. Their second act was to hire Mitchell Green to review all of the HOA's rules and regulations to identify any other provisions that might violate state law. He found 6, including a ban on solar panels that violated Colorado's Solar Rights Act, and a restriction on native plant landscaping that conflicted with water conservation laws. All of those illegal rules were eliminated. The new board also adopted a policy requiring legal review before any new rule was implemented, and they created an appeals process for homeowners to challenge violations before fines were imposed. Brenda moved away about 6 months later. I heard through the neighborhood grapevine that she and her husband had bought a condo in Arizona, in a community without an HOA. The irony was not lost on anyone. My clothesline is still in my backyard, 3 years later. I use it regularly from spring through fall, weather permitting. Several other neighbors have installed clotheslines too, now that they know they can. Mrs. Pembroke complained about those as well, but the new board politely informed her that they couldn't and wouldn't do anything about it. The whole experience taught me something important about standing up for your rights, even when it's difficult and expensive. Brenda had counted on me backing down, on me deciding it wasn't worth the fight. She'd bullied dozens of homeowners over the years, and they'd all complied eventually, because fighting an HOA is exhausting and costly. But sometimes you have to fight, not just for yourself but for everyone else who comes after you. My lawsuit didn't just protect my right to a clothesline. It forced the HOA to clean up all of their illegal rules, and it sent a message to the board that they couldn't just make up rules that violated state law. The new board is far from perfect. They still have rules I think are silly, and they still occasionally make decisions I disagree with. But they're more reasonable, more willing to listen, and more aware of their legal limitations. They see themselves as serving the community, not ruling over it. I still see Gerald sometimes at neighborhood events. He's never apologized, but he doesn't make eye contact anymore either. Sharon actually came up to me at the 4th of July picnic last summer and said she wished she'd voted differently during that board meeting. David just nods when we pass each other on our morning walks. The whole thing also got me interested in HOA law and homeowners' rights. I started reading more about the various state laws protecting homeowners from HOA overreach, and I was surprised by how many exist. Solar panel rights, clothesline rights, vegetable garden rights, flag display rights. Legislatures across the country have recognized that HOAs sometimes need limits on their authority. I even testified before the Colorado legislature last year, when they were considering strengthening the right to dry law. I told my story about Brenda's initial confrontation, about the illegal fine, about the lawsuit and the appeal. Several legislators thanked me afterward and said stories like mine were exactly why these protections were needed. The strengthened bill passed. It now explicitly states that HOAs cannot impose any restrictions on clotheslines beyond basic safety requirements, and it provides for enhanced penalties for HOAs that violate the law. If another HOA tries what Brenda tried, they'll face even steeper legal consequences. I've also become something of an informal resource for neighbors with HOA disputes. 3 different people have called me in the past year when they received violation notices they thought were unfair. I help them research the relevant laws, and I refer them to Mitchell Green if they need legal help. One case involved a woman who was told she couldn't fly a military service flag, which violated federal law. Another involved a prohibition on playground equipment that conflicted with state housing laws. Both were resolved without litigation once the homeowners showed the board the relevant legal provisions. It's funny how one clothesline changed so much. I installed it to save energy and reduce my carbon footprint, never expecting it would lead to a 2-year legal battle and a complete overhaul of my HOA's board and rules. But I'm glad it happened. The neighborhood is better for it, even if some people still miss Brenda's iron-fisted rule. I've thought about moving sometimes, maybe to a neighborhood without an HOA at all, but I've put down roots here. I know my neighbors now. I'm part of the community in a way I wasn't before. Fighting for your rights does that. It connects you to the place you're fighting for. My laundry is hanging out right now, actually. Sheets and towels flapping in the breeze, drying in the Colorado sunshine, exactly as the state legislature intended. It's a small thing, this clothesline, just a simple wooden structure and some rope. But it represents something bigger, the right to make choices about your own property, the principle that laws matter more than HOA power trips, the idea that sometimes you have to stand up to bullies, even when it costs you. Every time I hang out a load of laundry, I think about that morning when Brenda showed up on my porch, so certain of her authority, so convinced that I'd comply like everyone else. I think about Judge Kerrigan's ruling, that clear and decisive validation that I was right. I think about the appeals court's scathing opinion, about Brenda's face at the grocery store, about the recall election that changed everything. And then, I think about all the people who didn't fight, who took down their clotheslines or removed their solar panels or replanted their gardens because an HOA board told them to, even though the law was on their side. How many of them just didn't know about the protections that existed? How many thought it wasn't worth the fight? That's why I tell my story whenever anyone asks. That's why I testified before the legislature. That's why I help neighbors with their own disputes. Because knowledge is power, and knowing your rights is the first step to defending them. Marcus is installing a clothesline next week. He asked me to help him pick out the right model and show him how to set it up. Mrs. Pembroke will probably complain, but that's what she does. The board will politely ignore her, as they should. And Marcus's laundry will dry in the sun, saving energy and money, exactly as it should. The HOA budget is healthier now too, ironically. Without Brenda's constant legal battles and her expensive landscaping preferences, the association has actually built up a reserve fund. Dues haven't increased in 2 years. The pool got resurfaced last summer. The playground equipment was updated. Turns out, when you stop wasting money on unwinnable lawsuits, you can actually improve the neighborhood. I got an email last week from someone in Texas who'd found my name in an article about HOA disputes. She was fighting her HOA over a similar issue, and Texas also has a right to dry law. I sent her all my documents, Mitchell's contact information, and encouragement. She thanked me and said it helped her feel less alone in the fight. That's the thing about these battles. You feel isolated when you're in the middle of one, like you're the only person who cares about something that everyone else thinks is trivial. But you're not alone. There are thousands of people fighting similar fights, standing up to HOA boards that have forgotten they're supposed to serve homeowners, not rule them. My dryer sits mostly unused now. I still use it for things that need to be dried quickly, or during the winter when outdoor drying isn't practical. But most of the time, I use the clothesline. It's become a habit, a routine I actually enjoy. There's something satisfying about hanging out laundry, about the physical act of it, about the way clothes smell when they've been dried in the sun and fresh air. And every single time I use it, I'm exercising a right that I fought for and won. That never gets old. The neighborhood has changed in other ways too. People are more engaged now, more likely to attend HOA meetings, more willing to question board decisions. The recall election woke people up to the fact that they have power, that they don't have to just accept whatever the board decides. Meeting attendance is up. There's actual debate now about spending priorities and rule enforcement. The board has to explain and justify their decisions instead of just handing down edicts. It's messier and louder, but it's also more democratic, more responsive to what homeowners actually want. Frank O'Connor, the retired lawyer who joined the board, told me recently that he'd reviewed records going back 10 years. During Brenda's tenure, the HOA had filed liens against 17 properties for unpaid fines. Some of those fines were for legitimate violations, but several were for things like the wrong color mailbox or unapproved decorative rocks. People had paid thousands of dollars in fines, plus legal fees and lien costs, for violations that were either trivial or based on rules that probably weren't even enforceable. The new board has adopted a more reasonable approach. Warnings before fines, appeals processes, proportionate penalties. Revolutionary concepts, apparently. I've made peace with the whole experience now. At the time, it was stressful and expensive and consuming. I lost sleep over it. I worried about the legal fees, about whether I was being stubborn and stupid, about whether I should just give in and avoid the hassle. But looking back, I'm proud that I stood my ground. The money I spent on legal fees has been worth it. Not in any direct financial sense, I'll never recoup those costs. But in terms of the principle, the precedent, the changes it brought about, it was worth every penny. And I got most of it back through the fee award anyway. My relationship with my neighbors is better too. Before the clothesline dispute, I was just another guy in the neighborhood. People waved but didn't really know me. Now I'm the guy who stood up to Brenda. I'm the guy who changed the HOA. People stop to chat when they see me outside. I get invited to more cookouts and parties. I'm part of the community in a way I wasn't before. Even Mrs. Pembroke has mellowed a little. She still complains. That's just who she is. But she at least acknowledges me now instead of pretending I don't exist. Progress is progress. The legal documents from my case are all filed away in a folder in my office. The complaint, the motions, the briefs, Judge Kerrigan's ruling, the appellate opinion. Sometimes I take them out and read through them, remembering the journey. Mitchell's briefs are particularly good, clear, logical, persuasive. I've told him he should teach legal writing, and he just laughs and says he's too busy cleaning up HOA messes. He's stayed busy too. My case got him some publicity, and he's represented several other homeowners in disputes with HOAs across Colorado. He's become something of a specialist in the area, and he's good at it. He understands the law, but he also understands the psychology, the power dynamics, the way these disputes are never really just about rules and regulations. I ran into Patricia Rowlands, the HOA's attorney, at a continuing legal education seminar a few months ago. We ended up having coffee, and she admitted that she'd known the case was a loser from the start. But Brenda and the board had insisted on fighting, and her firm was happy to bill the hours. That's the problem with a lot of these disputes. The HOA pays with other people's money, so there's no incentive for the board to be reasonable. They can waste thousands of dollars on pointless legal fees, and it's the homeowners who ultimately pay through assessments. The special assessment to cover the legal fees in my case led to a new rule requiring board approval for any legal expenditure over $5,000, with notice to all homeowners and an opportunity for input. It's a small reform, but it makes it harder for a future board to wage expensive and futile legal battles. I sometimes wonder what Brenda thinks about all of this now. Is she sitting in her Arizona condo, still bitter about the clothesline that ended her HOA presidency? Has she learned anything from the experience? Does she regret not backing down when she had the chance? I'll probably never know. And honestly, it doesn't matter. The fight was never really about Brenda personally. It was about the system she represented, the mindset that HOA boards can do whatever they want, that state laws don't apply, that homeowners should just shut up and comply. That mindset is wrong, and it's harmful, and it's surprisingly common. HOAs serve an important function. They maintain common areas, organize neighborhoods, handle shared responsibilities. But they're not governments. They don't have unlimited power. They're bound by law just like everyone else. My clothesline proved that. A simple structure in my backyard became a test case for the limits of HOA authority. And the HOA lost because the law was clear and they ignored it. I hope other homeowners in similar situations read about my case or hear about it somehow and realize they have rights. I hope they know that state legislatures have passed laws specifically to protect them from HOA overreach. I hope they fight back when those rights are violated. Not everyone can afford to fight. Not everyone has the time or energy or resources. I was lucky in that sense. I had a good job with stable income. I could afford Mitchell's fees even before the fee award. I had the time to attend hearings and meetings. I had the support of neighbors like Marcus. But even if you can't fight through the courts, you can fight through the ballot box. You can organize with other homeowners. You can attend meetings and ask tough questions. You can vote out board members who abuse their authority. You can push for rule changes and better governance. The recall election that removed Brenda proved that. The homeowners of Meadowbrook Estates decided they'd had enough, and they used their voting power to change leadership. That's democracy in action, even on the small scale of a neighborhood HOA. 3 years later, my clothesline is still there, still functional, still doing exactly what I installed it to do. It's weathered now, the wood a little grayer, the rope a little more frayed. I'll probably need to replace some parts soon. But it works, and I use it, and every time I do, I'm reminded of the fight it took to keep it. That fight changed me, made me more aware of local governance, more willing to speak up, more engaged in my community. I serve on a couple of city advisory boards now. I vote in every election, even the small local ones that most people ignore. I pay attention to what my elected officials are doing. The clothesline dispute taught me that ordinary people can make a difference, that standing up for your rights matters, that laws exist to protect us, but only if we're willing to enforce them. It also taught me that HOA boards need oversight, accountability, and limits. They need members who see service as responsibility rather than power. They need rules that protect homeowners, not just property values. They need to remember that they work for the community, not the other way around. Meadowbrook Estates is a better place now than it was 3 years ago. Not perfect, but better. More democratic, more responsive, more respectful of homeowners' rights. That change started with a clothesline, a state law, and one homeowner willing to fight for what was right. I'm proud of that. And I'll keep hanging my laundry out to dry, letting it flutter in the Colorado breeze, a visible reminder that rights matter. that laws matter, and that sometimes the smallest acts of defiance can lead to the biggest changes.